Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Well, we are back for another episode. Bobby, it is great to see you today. How are ya?
I'm doing pretty good. It's still summer here, although I don't know when people will be listening to this, but still summer. It's probably a nice 80 degrees, and I'm loving it. I dread the winter. My wife loves it, but or she doesn't love it. I think she loves the fall. A lot of people love the fall.
The fall is so great. It's coming. We have fake fall here in Georgia, where it loves to give us a couple days of fall, and then it says no, and it goes back to being super hot. And it's very annoying when it does that to us.
That's how our spring is. We have like a few different springs here where it gets up to like 75, and then it goes back down to being 40, and it's this whole 2-month process. But for now,
So for those of you that don't know, so I'm in Atlanta and Bobby's in Illinois. So that's why we have different weather patterns, to talk about here today. But today we are picking back up. So we've been talking about that first 90 days of divorce, and we sort of talked about the first 30 days and what to expect, and then the next 60 days. And today we're talking about days 61 through 90, Bobby. And that is the mediation negotiation stage, also potentially discovery, if that's necessary. So why don't we just kind of kick off today with what people can expect from this kind of third segment, that 61 to 90 days of the divorce process.
Yeah, so great to be here. Great to see you, Greer, and talk about this, because at this point, days 61 to 90, the divorce is getting pretty meaty, if you will. Like, we're going to really be diving into the substance of this case, and in an ideal world, your case will be wrapping up. I mean, that's really the timeline that we're looking at for an uncontested divorce. I would say 85-90% of uncontested divorces can be completed in less than 90 days. So it's crucial during this period. And it may start, obviously, these aren't, how can I say, hard and fast timelines. Like, we can start negotiating our divorce before it's even filed. But to give you guys kind of a framework, I think it's fair to say within this 61 to 90 day period, that's really where negotiation is most likely to start happening, and for us to start discussing whether discovery is necessary.
Okay. So we're looking to negotiate. So hopefully, kind of step one, if everybody can get along between the two attorneys, or maybe even between themselves, you're going to be able to negotiate, come up with terms, and decide like, hey, we've agreed upon this. Maybe there's a couple things that go back and forth between each attorney. So this is, I would say, in your world, the ideal scenario, right? That you're able to negotiate without getting either the court or a mediator involved, right?
Yeah, and I think you kind of just accidentally touched on something that was really key, which was, as long as the parties can get along. I think there's a common misconception, and some of it's based in truth, that it's the lawyers that are throwing the wrench in the works, and if it wasn't for the lawyers, this case wouldn't be going on so long. I think that becomes much more true down the road with more contested divorces. The vast majority of us, divorce attorneys, we really want to settle these cases as efficiently as possible. And there is certain divorce attorneys, I think, that are more like sharks, and when they see blood in the water, they kind of ramp things up, and they aren't as inherently good at being diplomatic and solving cases. The vast majority of divorce attorneys are problem solvers. They're going to defend their client's rights. They're going to make sure that their client gets the best deal possible, but at the same time, they're going to be encouraging their client to stay objective and neutral and try to tone down the toxic rhetoric if that's happening, and controlling the emotional temperature of this whole case. So it's really about, within this first 0 to 90 days, can we be as diplomatic as possible? Can we not be triggered by our spouse? Can we take the high road when we feel like they're jabbing at us? That's going to be the biggest challenge, and the thing that opens this up to the possibility of a quick resolution.
Yeah, absolutely. I think it's really good to remember that when you're going through a divorce, you are probably or could be very emotionally charged. It's very personal for you. It's an emotional process, but you got to remember your attorney is not emotionally involved, right? So it's good to remember that they're kind of there to help you navigate, but they aren't as emotionally involved as you are, which is kind of the whole purpose. So it's
And
good to
don't,
have somebody that's thinking straight.
yeah, and don't mistake your attorney telling you to maybe let go of a certain stance that you have, or your attorney minimizing a certain perspective that you have, for your attorney not fighting for you. Your
Mhm.
attorney sees the forest through the trees, has seen these cases, 100, if not 1,000 times, and knows from all that experience what's really going to matter down the road. So if you're fighting over something small and they can see that, or they can tell that it's probably based in some sort of anger or resentment that you have, and it's not truly significant, because they're encouraging you to let it go doesn't mean that they're not fighting for you. They're actually trying to save you money, stress, time, and all that. And that is an interesting, how can we say, tension that arises between attorneys and their clients in the divorce world. Is like, we have to tell our clients to let go of things. It's not worth fighting for this. And then sometimes the client does perceive that, of like, hey, why aren't you sticking up for me? Why aren't you fighting for me? Well, it's like, well, fighting for you in that sense might not get what you want, and is going to cost way more money, and is going to cost way more, take a lot of more time. So we're fighting for you. Just sometimes it's like, and I hesitate to say this analogy, but sometimes our kids don't realize that we're really looking out for them, and they get angry at us. Same sort of
Yes.
idea. Same sort of
Yes.
idea. Like, we've been down this road before. We have this experience, and so we're trying to use that to truly help you. I promise.
That is such a great perspective, Bobby. So I appreciate you, saying that. And it's like that, pick your battles, because there are so many things to talk about, to negotiate, to agree upon in a divorce. And there are just gonna be some things you're gonna have to kind of let go of, because there's other things that it's time that you really do want to say, hey, no, this one is really, really important to me. So but you do have to kind of pick them, right? They're not all gonna work.
You got to pick
So
them.
let's
Just to finalize the last thought on that, is like, there's so many cases where they get really contested, and we spend, let's say 18 months and 2 years fighting over it. And where we end up, if we were to go back to the first 90 days and the first proposal that was offered, they're usually very close to that proposal. So it's like, we have to take this really long journey and go through these, kind of jump through all these hoops, and duke it out back and forth, spend six figures in attorney's fees between the two parties, and then we end up in the same place. And so that's why I'm such a big believer, and there's a more efficient way to do this. So
Yeah.
sorry,
Yeah,
I'll
that's such a
get
good
off my
point.
soapbox, and we can dive in.
It's okay, it's okay, it's a great soapbox, it's a great soapbox, but that is why you hire an attorney, to have one that's been down this road before and can give you, solid legal advice. That's part of why you have an attorney. So, obviously our first step would be, okay, maybe we could negotiate this agreement, between themselves, between attorneys, but then if that's not possible for everything, or potentially just a couple of items, there may just be like a few things that you're not able to agree upon. The mediation is kind of the next step, and a mediator is who would actually be over that. So why don't we just kind of start with, you know, what does that mediation process look like, and how do you decide on who's going to be a mediator?
Sure. So the well, let me back up, and I don't want to go out of order here, but I do want to talk about just briefly, because you said negotiation, and I'm not sure if we talked about it in the previous episodes, but I want people to understand just how much the power is in their hands to negotiate this divorce. And they can negotiate it at any time. They can negotiate it over the dinner table. They can negotiate it before they get their attorneys involved. They can negotiate it after they have attorneys. They can do it with their attorneys, without their attorneys. There is no one way to negotiate. The only rule about negotiation is keep the conversation productive. Try to keep it objective and not include, limit your blaming, your finger pointing, etc. This actually came up because of a family member going through this process right now, and there's only one attorney involved, and there was kind of a misconception that one attorney was representing both people. And one thing to understand is that one attorney in this process cannot represent two people. If you think about it, an attorney's job is to tell their client kind of the unadulterated truth about their opinion, their advice. Is this a good deal or a bad deal? And they have loyalty to that one client. If they're representing two people, well, they might be saying to one person, this is a good deal for you, and another person, this is a bad deal for you. And an attorney can't be doing that. So I just want to set the table as far as negotiation. That is possible really at any step of the game. I'm always hoping that my clients are attempting to negotiate with their spouse, because the best agreements, the quickest agreements, come from the parties themselves being able to sit down and talk. So with that being said, if that does not work, then that's when we're getting the mediator involved. And the mediator, so the first big challenge in mediation is we have to have two agreements. And we've decided to do mediation at this point because we've struggled to agree on anything. But we have to have two fundamental agreements when we start mediation. One is that we both want to do mediation, and that we're bought in enough on the mediation process to move forward with it. And two, we have to agree on a mediator. So for the first one, my piece of advice is to just, when you have that conversation with your spouse, just keep it really high level. Don't blame. Take some of the blame on yourself. You could even say something like, hey, I want to talk about the divorce. I know that we've really struggled to have productive conversation. You know what? A lot of that is probably my fault. Obviously, I'm upset about this. I think it's really overwhelming and emotional. And so I'd like to explore using a mediator, because I think that'll maybe help take some of the emotion out of it. Are you open to going down that road with me so that we can maybe keep the lawyers out of this as much as possible? And there's a very high likelihood that your spouse will say yes to that. And then at that point, you can say, well, we need to choose a mediator. One way that we can do it is I can research and find a list of, say, 3 or 4 mediators and that I would be agreeable to, and give you that list. And then maybe you pick one. That's usually the best way to do it. Give this the other spouse, or do it vice versa. And if they say, oh no, I'm not comfortable with that, and say, okay, well, would you be open to offering me 3 or 4 mediators, and I pick one? So you got to get over that hump, get that mediator selected. And then at that point, you're off to the races.
And can you kind of explain maybe like what the difference is between having a mediator and then having your attorney? Because that might be confusing for people of like, wait, well, why do you need both?
Yeah, absolutely. So your attorney can act as a facilitator in a settlement conference. I mean, they could have a settlement conference with you and the other side. Let's say the other side is not represented. They could do a meeting at their office or over Zoom where they're talking through the issues. But that attorney is very limited in the type of information and the type of tone that they can take with both sides, because they do have this ethical obligation just to one side. I mean, the table, the field is inherently uneven when you have an attorney and the other side doesn't. So it doesn't always lend itself to the most productive negotiation. When you have a mediator, and usually mediation is without attorneys. You can do attorney-assisted mediation as well. That usually happens in more complex cases, but I'd say in 90% of the cases that are out there, it's just the mediator and the parties. And that's better. Always, the more professionals that get involved in this process, the more complicated it gets. You start to play this game of telephone. You start to kind of, it's hard for a mediator to really get some momentum if there's also attorneys involved and they're breaking to talk to their clients and coming back. It's just more difficult. So you're just going to have you, the mediator, and your spouse, and that mediator is completely objective. Their number one goal is to keep things neutral and productive and solution focused in the process. And then they can break off with each party and say, okay, well, let's take a break. Let me talk to your spouse about their position on this and see if I can understand what their interests are, their motivators. And then they talk to you, and then they come together and they might have a proposal, but they're not tied to you or the other side. They just want to see an agreement happen.
So are they kind of giving typical like scenarios or options of like, okay, let's say, they are not able to agree on, the time with their kids, right? And who's going to have who win. So is it the kind of thing where they're like, well, it could look like a schedule like this. This is an A schedule. This is a B schedule. This is a C schedule. Like, what is that? What does some of those conversations look like?
Yeah, absolutely. With the scheduling, the mediator is what's great is that the mediator is going to have the experience of having done this with, an experienced mediator, probably hundreds of other couples. And your scenario, while unique to you, is not inherently like, I, I often say that whatever your experience is probably similar to the average experience. If you experience something, there's most likely other people are experiencing it too. So this mediator is going to go, okay, well, I've dealt with, having a doctor on one side who has on-call shifts and let's say a nurse on the other side who also does as well. Here's the schedules that have worked for them, and we'll be able to propose some different schedules. And if one side says, well, that doesn't work for me or that doesn't work for the kids, then let's explore why and what the inherent issue is. And maybe they have to eventually uncover that it's not about the schedule, it's about the child support. And they're concerned if they don't get more time, then they're going to have to pay too much child support. Well, at least we're discovering that in the process and we can talk through a solution.
Now, does this mediator also have a counseling degree? Because it feels like, that there's some extra skills here that would come in handy.
Great question. I mean, actually, in Illinois, there's no attorneys can be mediators and non-attorneys can be mediators. Counselors
Okay.
So it's really up to you to figure out what degrees you want your mediator to have. And as you go through the process and start to research mediators, you'll see that some of them are licensed counselors, licensed therapists, that sort of thing. And that might be more appealing to you and your spouse than using an attorney. Whereas the benefit of using an attorney is that they're very familiar about what happens if this goes south. And they can talk to you about like, hey, a judge isn't going to go for that. Or, hey, if you don't agree to X, Y, and Z, or if we don't come up with a compromise, then you're looking at this daunting court process in front of you. And so an attorney can give people a lot of perspective of what's to come if they can't figure it out, while the counselor, the therapist, is probably better at being patient, better at what's the expression? Basically, if things start to get really contested and toxic, they're probably better at working through that and getting communication back on track. So there's pros and cons.
Well, and speaking of that, ideally, you're hoping that in this mediation situation that you're able to be reasonable and come up with some solutions. But what if you do feel like you're being attacked by your ex as you're in this, situation? How are there any like tips of how to kind of make this conversation go well? Because, it still is pretty emotionally charged and people probably have their opinions and they might not always be the same.
Yeah, and I think a good mediator, well, one, if your spouse is attacking you or you feel like there's just a ton of finger pointing and it's more problem focused and solution focused, like they want to just pin the problems on you, the key is to not take the bait, to let the mediator handle it. That is one of the things the mediator should be good at doing, should be trained in doing, is de-escalating these situations and calling that sort of behavior out from the other side. And a mediator will call it out. And if it continues, the mediator will say, listen, guys, we can't mediate if we don't continue to be solution focused. If we just focus on problems and blaming and relitigating the past, then we're not in the right space here. And sometimes that happens. Some mediation is not some magic pill that always works. Sometimes it just devolves and one or both of the parties isn't quite ready to mediate and get it done. There's too much of that emotional turmoil, and litigation is somewhat inevitable.
Oof. Okay, so let's say that the mediation, well, one, how long would you expect to be in a mediation typically? And then if it does go well, then what happens next?
So a I would say on average, a mediation could be 2 to 4 sessions of a couple hours. Most of the mediators that we work with take a retainer of somewhere between $3,000 and $5,000, and that's about, depending on what their hourly rate is, about 10 hours of mediation. So a couple hours at a time. You do the math. That's a few sessions that are going to happen. And that's plenty if conversation stays productive to work through all the issues. And sometimes there's issues that you kind of address on the first time, maybe try to resolve on the second time, but you can't. You put them in, what would be called a parking lot or some area where it's like, okay, well, let's save this to the end. Let's keep our momentum going and see if we can address these other things, and then talk about the dog at the end of this to see if maybe we can figure that one out, or talk about who's going to get that extra overnight. We can figure that out at the end because we've agreed on where the children are going to go to school. We've agreed on who's going to be the primary parent, but we can't quite lock things in. So let's just save that for the end and figure out some other issues before that. So let's say that we do all that. We navigate through all of it. We have an agreement. At that point, the mediator is going to draft up what's called a memorandum of the agreement. And then your attorney is going to turn that into the formal document. That's the marital settlement agreement. There's going to be some final review from the attorneys, but we should be like rounding third and close to home at that point and just signing off on these documents if mediation was truly effective.
Okay, I love that. And you love that. I can tell you would be so excited if it all worked out and everybody had agreed. It's very, very good. Now, if they don't agree through the mediation process, then is it typically that you're going to litigate? Is that kind of the next step, or what happens?
Yeah, I mean, if mediation doesn't work, and mediation can be, it can be given plenty of opportunities to work. Usually judges are pretty patient about mediation, especially if the parties start it soon into the process. Judges will give it a few months to work, because judges, like everybody else in this process, the vast majority of us want to avoid that litigation because it's so destructive to, especially in cases with children, it's so destructive to the co-parenting relationship. So if we can get this done, if at all possible, without litigating, we're going to do that. But if it does break down, what we're looking at next on the custody side, there's a high likelihood that a guardian ad litem is going to be appointed. And that's an attorney that represents the children and is the quote unquote eyes and ears of the court. And they do an investigation. Both parties pay for that attorney. It's not cheap. And then that attorney tries their best to broker a deal, gives recommendations to the court. The court then takes those recommendations. Eventually, if the case goes to trial, the court will make a ruling. partly on those recommendations, although the judge can deviate from them. Doesn't usually, but it is possible. So that's what happens on the custody side. And then on the financial side is when really we see discovery getting started, most likely. And
Yeah. So why don't we talk a little bit about discovery? When is it kind of the right move to do discovery in Illinois? I mean, do you always do discovery, or is it particular cases that discovery is necessary?
yeah, discovery it's comprehensive, it's daunting, it's expensive. So if we can avoid it, we're going to do that. We're going to avoid it by just making small requests to the other side on documents that we'd like to see. If it usually is a sign that we need to start discovery if the other side is really slow to get us back the documents we're requesting, if they're incomplete. Those are the two biggest reasons. And then at that point, we have to have a conversation with our client about, does it make sense to do discovery? Because it's going to take time, it's going to be expensive, and they're going to issue discovery against us as well, most likely. So that's when we really have to have a clear talk on what are we likely to find in this discovery? What do we think we can find? And is that going to be enough value to justify this expensive, tedious process?
Yeah, and so you're talking it can be very expensive and tedious, like you said. So I'm tracking on that. With discovery, is it always everything financial, or is it like a particular area? Does that make sense? Like, can you refine it,
You
or
can
is it
refine
kind of
it. I mean,
complex?
if you just wanted to go get as laser focused as possible and just go in and get the documents just related to the other side's restaurant or just related to a certain 401k or something like that, you could do that. But what we see most often is the other side just returns kind of this blanket request for discovery to you. So now you're just being kind of narrow and then they're being broad and you end up having to do all this
Mm.
work. So it's really once we kind of get out of the world of just voluntary disclosures and being transparent and cooperative, it is much more difficult to be laser focused. The other option would be, instead of comprehensive discovery to the other side, and this is a great option and one that we use, is to just start sending out subpoenas to third parties. So discovery are requests that go to the other side. You're asking your spouse, turn over your bank statements, turn over your credit card statements. Subpoenas are requests that we send to the bank and send to the credit card companies and say, you just give us these documents. And the banks and the credit card companies, they don't have any dog in this fight. So they just have, a secretary who's like literally hired just to do this. So that person is much more efficient usually at just turning over the documents, and there's not as much of a fight. So that's one way where we can be a little bit more focused in our discovery.
Okay. All right. So after discovery, then kind of what's the next thing?
Yeah, so discovery is going to probably is definitely going to take us through that 90-day period, and really we're issuing that discovery within the first 90 days most likely. It could come after. Again, usually discovery is not going to happen if mediation is being productive, because discovery is it's the antithesis of mediation. It's saying, I am requiring you to do all this extra work, whereas mediation is much more solution focused. So we're going to issue our discovery request around the time mediation is breaking down, when we decide the other side isn't being cooperative. And they're going to, that whole discovery process is probably going to take 6 months or so. And then at that point, our next big move in the case is either going to be another round of motions because we have more information now and maybe there's other requests, or doing something called a pretrial conference. And that's where we meet with the judge. It's just the attorneys. We tell the judge our side, they tell the judge their side, and then the judge gives us recommendations for settlement. But that's usually not until like the 6-month mark of the case, and things are pretty contested at that point.
Okay, Bobby, I don't know about you, but negotiation is just sounding better and better and better. The more I hear, I'm like, how can we negotiate this thing?
Absolutely. Absolutely. As someone who's been down this road hundreds of times with clients, it's the reason that I am so willing to jump on the soapbox and talk about negotiation and mediation and figuring out how we can stay out of court when we do this, because it's rare that we see a case that things worked out better because we litigated. And I'm certain there are people listening right now that might see this on social media that say, well, my cousin did have to fight for their time as a father, or my mom had to fight for alimony. Those are real scenarios, though that is necessary. And we will do that for clients, but in the vast majority of cases, we can sometimes get the same result or a better result without having to go to trial.
Yeah.
Leave it at that.
Yeah. I love that. All right. So we have covered a lot over the past 3 episodes. This was kind of a 3-parter. And so let's just do a little recap, Bobby, of the 90 days. So when you are going through divorce, it's going to start with you get served. And then after you get served, kind of just recap for us, what happens in those 90 days.
Yeah, so you're going to get served, or you're going to serve the other side. Then there's going to be an appearance that's going to be filed next. There's a deadline to file that appearance. That's the official document that says I'm representing myself, or your attorney's filing that and saying I'm representing your spouse. After that appearance is filed, there's also something called an answer that they're going to file that's going to address the allegations in the original petition. There's also something called a counter petition. Don't get overwhelmed with all these documents. They're just kind of the legal foundation for starting the case. Once that's done, there'll be an exchange of financial information called financial affidavits. Your attorney will talk to you about whether or not any motions are necessary to resolve some temporary issues, parenting time, child support, alimony, who's in the house, that sort of stuff. And then we're going to dive into mediation, negotiation, and discovery. So that's your first, and hopefully settlement. In an ideal world, we're settling the case anywhere from, I think our firm record is like 8 days that we were able to resolve a case, which is kind of incredible.
Wow.
I think that was like, you set that record, and then I think 25 days, we've done one in 26 days. Those are quick turnarounds. But really, within the first 12 weeks or so, I think it's very possible to resolve a divorce if we keep it diplomatic.
Yeah, absolutely. Well, Bobby, as always, thank you so much for all of your insight today and over the last couple of podcasts as we talk through the 90 days. And if any of you have questions, anything that you want us to talk about, please just put it in the comments, reach out, because we would love to discuss things that are on your mind. And hope you have a great week. And we'll be back again next Tuesday for another episode.
Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.